Hello everyone and welcome to Daily Newspaper Analysis, which is brought to you by Losico. Today we have two articles for our discussion, but since they were about the same topic, so we have amalgamated both the articles. The first one is from the Indian Express, which is titled as Reading Maratha Quota Verdict, and the second is from the Hindu newspaper, which is titled as Against Excess. So both these articles talk about the validity of the Maratha reservation that has recently been given and as to what has been the Supreme Court's verdict on this particular issue. And secondly, we did not have a news in flash column today actually. So this article will be analyzed by me. My name is Sheva Khan. I had completed my BA LLB law degree from Law College Dehradun from Uttaranchal University in the year 2019. I was fortunate enough to do it with a gold medal in my batch. I have been a national debater and a public speaker. And here at Losico, I work as the current affairs expert and manager for free content and outreach. And if in case you wish to connect with me, you can always join me at my LinkedIn as well as Twitter handle. Both are available in the description box. Let's see what is the multiple choice question from yesterday's discussion. World Pulmonary Hypertension Day is observed on. Your options are 8th March, 1st May, 5th May, or 30th April. If you know the answer, you can put it down in the comment section below. This is the descriptive question for the day. Discuss the relevance of the Indira Sahni case when it comes to the reservation system in India. It's a very important question. You can attempt it within a word limit of 250 to maximum 300 words. With this, let's get started with our discussion, which is a very important and interesting discussion for the day that talks about the Supreme Court verdict on Maratha quota. Recently, what has happened is that a 5-judge bench of the Supreme Court struck down the Maratha law granting reservation to the Maratha community in admissions and state government jobs. Now, here we need to know and understand as to which article of the Indian Constitution provides for the equality of opportunity in public employment. So basically, it is Article 16 of the Constitution which promises that every individual, every citizen in the country shall be treated equally by the state in order to give admission in the public employment. But then again, Article 16 Clause 3 also presents and also makes a provision that the state can make provision for the people and for the communities that are socially and educationally backward. In this direction, the Maratha, that is the Maharashtra government, had also given and granted reservation to the Maratha people, those who belong to the Maratha community in admissions and the state governments. But then, why has this been struck down by the Supreme Court? So let's understand in detail as to what are the questions of law involved in this particular issue. The first one is whether the Indira Sahni versus Union of India 1992 judgment had to be revisited. So the 9-judge bench held that the criteria for a group to qualify for reservation is social and educational backwardness. And it also reiterated, which means that it repeated again that 50% limit or the 50% cap to vertical quotas, except in exceptional circumstances, should not be crossed. Now, here are two things that we should consider. Firstly, that what should be the criteria or what should be the reason for granting reservation? So it is said that it is only and only social and economic backwardness. Now, for sure, the EWS quota, which is the economically weaker section quota, must be coming to your mind. That how then the quota was allowed. So if you remember, even the EWS quota has been much debated, and even till date, many a times it is debated to be unconstitutional in nature. But currently, it is taken up, and many a times it is also taken up as an exception to the 50% quota as well. But still, as a general rule, the only criteria for reservation is the social and educational backwardness. And then that is why we will have to consider as to whether the Maratha people, the community that has been granted this particular reservation by the Maharashtra government is or not in the category of socially and educationally backward class or not. And the second thing that we need to see here is that there is a 50% limit to the vertical quotas. Now, by this we mean that whenever the reservation is granted, now for this we also need to understand as to what are we trying to say by the vertical quotas or vertical reservation. Basically, what happens is that whenever the reservation is to be granted, it can take place in two methods. The first one is the vertical method, which means from down to upwards or upwards to downwards, which means a line that is vertical in when we try to see it. And the other kind of quota or reservation is the horizontal quota. I'll give you a very good example of this. For example, we have the people at large, like all the people in the society, but then we also have the scheduled castes, then we have the scheduled tribes, and we also have the other backward classes, which are the OBCs. Now, when the reservations were granted to these communities, these were the vertical reservations because the differentiation in the status of these communities was on a vertical ground. But if, let's say, if women amongst the SCs or women among the STs or the OBCs are also granted reservation, so in a way they belong to the same category or the same community, but still they are given some kind of reservation. Now this reservation, which is within a particular community, is considered to be as the horizontal reservation. So I hope my point is clear to you that when we put the communities one above the other or one below the other, that is a vertical kind of reservation. And when we grant reservation to any particular class of the people within that particular community, that is considered to be as the horizontal kind of reservation. So that is why when we talk about this 50% cap or 50% limit, so it applies to the vertical kind of reservation, except in the exceptional circumstances. And that is why the Supreme Court held clearly that there is no need to revisit Indira Sahni, and the provisions are simply applicable in this regard as well. And if we try to understand whether or not the Maratha fall in these above two questions or not, so the Marathas are a dominant forward class and are in the mainstream of national life. And that is why even they would not even fall in the exception cases or the exceptional cases. And thus they do not even belong to the socially and educationally backward classes. And thus giving these quotas or reservations to Marathas would not even fall in this particular category. And thus the Supreme Court has held that the situation is not even an extraordinary one. So if we try to understand the background of this particular issue, earlier, the Bombay High Court had upheld the validity of the Maratha reservation in principle, but it ruled that the law could not have fixed percentage above what was recommended by the State Backward Class Commission headed by M.G. Gaikwad. But now, completely and in finality, the Supreme Court has struck down this particular quota. The next question of law now that we need to consider is whether the state has the power to identify the socially and economically backward classes or not, and does it have the power to exercise the 102nd Amendment. For this, it is very, very important for us to understand that the Supreme Court has held that the final say in regard to inclusion or exclusion in any of the lists of the socially and educationally backward classes is firstly with the president, and in case any modification, alteration, inclusion, further exclusion is to be made, so it will be done by the parliament. So in a way, we can see that the state governments are no way empowered to make any changes, inclusions, exclusions, or alterations to the list of the SEBCs, which is the socially and educationally backward classes. So if at all anything has to be included into the list, it shall be the power with the president to do so. And if at all any change has to be done into it, whether any kind of exclusion has to take place or any other alteration or modification, then the parliament is empowered. So in a way, no other authority than the center, and that too, the president and the parliament in the center, have the power to make any changes in the SEBCs. So the president shall be guided by the commission set up under Article 338B, and however, the final determination will be done by the president. So one thing that we need to note is under Article 338B of the Indian Constitution, we have the National Commission for Backward Classes. So earlier it was a statutory system, but later on, by the 102nd Amendment, it was added and amended, and under Article 338B of the Indian Constitution, it was made a constitutional body. So for any kinds of inclusions to take place in the list of these socially and educationally backward classes, the National Commission for Backward Classes makes recommendations to the president. But please note that the final determination or the final decision is yet in the hands of the president. And while the identification of the socially and educational backward classes takes place, it will be done centrally. The state government can retain the power to determine extent of the reservation and make specific policies in the spirit of cooperative federalism. So yes, there are some powers which are granted to the state government in this regard. So which are that the state government has the power to determine that till what extent would it want to give the reservation, of course not exceeding the 50% cap, and also it can make specific policies in the spirit of cooperative federalism. So something that enhances the spirit of cooperation between the center and the states, and not something that enhances competition between the both. So a fresh list of the socially and educationally backward classes will be published by the National Commission for Backward Classes, which will be notified by the President soon. So this was all for the day. We hope it was a good and informative session for you all. Thank you so much for staying tuned with Law Seekho. Please subscribe to our channels for such more updates to come daily.